Today, the government announced plans to give prison guards or custody officials the green light to use, and the phrase that was used was reasonable force to make offenders appear in the dock or via video link. For prisoners facing fewer years in prison than Letby, in other words, convicts who will be freed one day, these laws, also proposed by the Ministry of Justice, will mean anyone who refuses to allow a sentencing hearing faces an extra 2 years in prison. As I say, not applicable for Letby, but perhaps in other instances where one day somebody stands a chance of being released, the idea of going along with what the judge is asking you to do may be something that compels them or persuades them to attend their own sentencing hearing. We can look at recent examples where that's just plain stopped happening. Thomas Cashman, he refused to attend the sentencing for killing 9-year-old Olivia Pratt-Corbell. Jordan McSweeney, the murderer of Zara Alina, was another one. You can, I'm sure, think of others as well. There's a danger, of course, that some criminals will relish the opportunity of making a public statement. I dare say, for instance, if you think of one particularly high-profile murder, one particularly brutal killing, the killers of Lee Rigby, Michael Adeboale and Michael Adebolojo. If you gave them the chance to face the court, perhaps they'd use it as a chance to express views that the family who would be in court would find extremely difficult to handle. So it's not as simple as it sounds, but it would appear that the legal process is in train to change this. I want to introduce you to Joseph Cottery-Monson, who's a legal commentator, but also director of the Mary Monson Solicitors on Fleet Street, specialising in infanticide cases. Joseph, welcome to you. I was really struck just in reading up on this story tonight by a piece you wrote for LBC, for the opinion section of the website, about what happened when Letby didn't appear before the judge. And one particular phrase really resonated for me. You said the principle of a justice process behind closed doors or without the participation of the evil architect herself falls short of its duties to them, and by them you particularly mean the families who are in there listening to sentence being handed down. Why is the principle of justice being seen to be done so important?
What a question to start on in the context, Colin, of this terribly difficult case. Justice being seen to be done. Justice serves several purposes, doesn't it, Colin? It's a deterrent if it's public. It serves as some type of satisfaction for a wrong for the victim. Yeah. It's not the same as revenge because it has limits, and it also acts to civilize those desires for revenge. It prevents vigilantism. It protects us in moments of being severely wounded from our basest instincts, however justifiable those might seem, not just in the moment, but in the context of a case as horrific as this. And for all of those reasons, justice must be public in as much as it's possible. Tremendously difficult, of course. The temptation is to regard justice, I think, Colin, as some type of completion and redress that's perfect. It isn't. As my late mother, Mary Monson, the great Mary Monson, used to say, don't expect when you go to court to clients, don't expect to go to court and experience some kind of well-planned out movie. At best, you're getting an amateurly acted local production in your local theatre. Justice does its best to serve those purposes. For families of victims in murder cases, justice will always be an inadequate process because it can never come close to putting them right. Having said that, the principle of conviction and sentence being seen by them and the way that victims are being given a role, I think that's welcome. I think there's only so far it can go for some of the reasons that you've already hinted at as far as practicality and asking for demanding engagement from somebody who's already getting a long sentence.
Joseph, just to underline a word you used there, movie. A lot of people, thank goodness, never really have much contact with the criminal justice system until something dreadful happens to them, and then they're in it. And their only reference point in many instances will be what they've seen on television. And what they often see on television is the dignity of the court enhanced in a sense by shifty looking or contrite looking or none of those things, defendant looking squarely at the judge as the judge hands down a sentence. That's in a sense a strange convention. We've got used to that idea of the dignity of the court being respected by criminals, but it feels like it doesn't take very much for it not to become the done thing, and it feels like we're moving away from it being the done thing.
I tell you, I mean, this is not. This is a level of sophistication, if you don't mind me saying, of thought and approach to this problem that I haven't experienced from somebody in your seat yet, Colin. But you are really identifying some of the challenges and tensions that exist in how far you can go, because that thing, dignity and propriety, it is actually quite fragile, and it's difficult to force it. And I think in recent years, Dale Cregan, I think, was the one who popularised. Remember that odious double police
Manchester police killer?
That's right, of two female police officers 10 years ago, who popularised it. And I think at that point, people realised, well, you don't actually have to attend in these hearings, and if you do, you can be disruptive. But it's hard. One of the historic tensions, one of the things that was a leverage upon defendants to behave well in those hearings, was that these long sentences of 30, 40, even years, even whole life terms, simply did not really exist. As a result, there was always that hope that if you behaved, you might get a slightly lower sentence. But where, as you say, where is the motivation to behave in that way if already the sentence that you get is so great? Now, that as to whether that advocates or leads to a narrative with regards to engaging with offenders in some cases, I'm not really going down that road. But I think the practical effect of where we actually are, well, it's that you have a defendant who can be commanded to attend but can't be motivated to engage. You can't force somebody to motivate, to look, to be quiet, to be respectful, and of course, while those movie moments don't necessarily exist on a day-to-day basis, courts can actually occasionally, despite that early quote that I gave you from Mary, courts can actually be places where redress and truth and sense and also rehabilitation and the bringing back in of defendants on clearly on lower level offences through recognising their guilt and saying sorry, and, that they can be brought back into society as part of those processes, which is another purpose of the criminal process. Of judges sentencing exercise in less serious offences, is to actually see how the court system can work to reduce the chances of offending through being constructive, and that only works if there is engagement on all parts.
Is it not possible for a judge to say to someone like Letby, who is nary going to see the light of freedom again, look, you've got a whole life tariff, but we want you to play ball, because if you don't, you will find that your incarceration, miserable and infinite as it is, will be even more miserable. In other words, some of the privileges you enjoy in your new life will be less obvious.
Well, you hinted at that, Colin, as something that you might have discussed in a previous programme, and funnily enough, in some of my writings and conversations on the subject, it's occurred to me as to whether I should broach that, because it struck me as a logical step. Although I guess the question is, how far do you go? Do you put people on bread and water? Do you put them on hard labour? How much can you deprive somebody of their humanity to the extent that they almost no longer exist in the world of in the world of civilized, and irrespective of whether you think these people deserve that or not, I think once you've probably sentenced somebody to that level of diminishing of hope in their future, I think diet and whether you let them speak to other people, it becomes more and more meaningless, I suspect.
Yeah. A final thought, and I'm coming back to the piece you wrote for the LBC's opinion piece section, and you're talking about the family statement. Many families, you wrote, treat this public statement and the opportunity to make it in the presence of the murderer as part of the process of grieving, a final duty to their loved one. That really struck a chord for me, that final duty to their loved one. It feels like it is a cathartic process, but I just wonder, I'm a little uncomfortable sometimes about what, at any move towards the criminal justice system becoming more emotive. It seems to me one of the whole points of the justice system must be to take passions out of the equation, to deal only in fact. But you say there it serves a vital purpose, and a purpose that's slightly been thwarted by the non-presence of the defendant.
Yeah, and I think that in certain circumstances a crime is, and I share those tendencies towards being cerebral more than emotionally reactive. I'm a defence lawyer, for crying out loud. I'm somebody who believes in looking at the whole picture, and I think in most cases, especially during a trial, once you're talking about, for example, some of the changes that are proposed in sexual offences cases, which are so emotive to make it easier for people to be convicted against the weight, in some cases, of the evidence, I think that's tremendously dangerous. That's our emotions ruling our logical side in a negative way. But when you're talking about sentencing, in a murder, already against the backdrop of a long sentence, especially these very horrific, extremely horrific murders, which are so brazen and to use the word again, odious, I think it does become as much as possible and as much as practicable, really, about the victim, and that sentiment which no family should feel they are obliged to have, as part of the saying goodbye, to say those words. Well, that probably shouldn't be deprived. They shouldn't be deprived of that.
The thoughts there of Joseph Cottery Monson. Joseph, thank you so much for your article for the LBC website, but also for your thoughts this evening on what appear to be legal changes pending that will, insofar as it is possible, compel an offender, sometimes an offender who's committed, to use Joseph's phrase, the most odious crime, like Lucy Letby, who was found guilty last month of the murder of 7 babies and the attempted murder of 6 more.